Welcome to Our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law Section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to a special edition of Our Curious Amalgam. I'm Alicia Downey. The annual spring meeting of the ABA Antitrust Law Section is the premier event of the antitrust and consumer protection world. At the 2023 meeting, the Our Curious Amalgam team recorded interviews with more than a dozen leaders of competition agencies from all over the world. We asked each of them about their current enforcement priorities, what enforcement trends they see on the horizon, and tips for practitioners representing parties under investigation. We also got to know our guests a little bit better on a personal level. The title of today's episode is What's Happening in Germany and Spain? Conversations with Competition Law Enforcers at the 2023 Spring Meeting. In the next half hour, we'll bring you the interviews that my co-host Sergei Zaslavsky and I conducted with the leaders of the national competition agencies in Germany and Spain, respectively. First up is Sergei's interview of Andreas Mundt, the president of Germany's Bundeskartellamt.
Hello, my name is Sergei Zaslavsky, and today I'm talking to Andreas Mundt, president of the Bundeskartellamt. Bundeskartellamt, also known as FCO, or the Federal Cartel Office, is the agency that enforces German and European competition laws in Germany. And Andreas Mundt has been the president of the Bundeskartellamt since 2009. President Mundt, welcome to the program.
Yes, hello. Thank you.
Could you please tell our listeners, what is the top enforcement priority for you over the next year?
Yeah, we live in times of turmoil in Europe since the terrible attack of Russia on Ukraine. And of course, this has a lot to do also with our work. Inflation affects everyone. In Germany, I know it's the same in US, but in Europe it's a bit different because at the beginning it was very much energy driven through the dependence on Russian oil, Russian gas. So that is a huge point for us. We did a sector inquiry in the mineral oil sector that is still going to be continued. So that is a top priority, and I think it will be like that for some time. Also, new competencies with regard to subsidies in energy price relief measures for electricity, gas, and distant heating. So energy plays a big role. The second top priority, of course, is digital. Digital enforcement remains on the agenda. We are now in a phase in Europe where we do not need to discuss anymore. We implement new laws, the DMA at the European level, but mostly for us, Section 19A. At the German level, we have done lots of designation proceedings against companies. Just yesterday, initiated a new proceeding against Microsoft. We have lots of cases going on with regard to conduct in this area. Google News Showcase, the Meta virtual reality headset that can be used without a Meta account now. So we are very proud, in fact, that also 19A came into effect only 2 years ago. We were able to have so many designations in a quite short period of time, and we're very proud that we have already concluded 2 important cases in this area. One, by the way, again on Meta. It's a small case about the virtual reality glasses, but it is an extremely important case because it's the first time that the user can use a Meta, a Facebook service, without combining all the data he leaves on his Facebook account. He can opt for a single Meta account and the data stays there. So that's an important case for us. So digital remains at the top. And of course, what always remains important are the bread and butter topics like cartel enforcement. We have started a lot of proceedings in 2022. That will remain important also, of course, in 2023. Lots of dawn raids that we have done. And merger control is always on top of the agenda. 800 mergers to be filed to the Bundeskartellamt in 1 year. That won't be different in 2023. Last year, 8 of these went into second phase. 1 was prohibited, 2 others were cleared with remedies. So it covers all areas, but in fact, energy and digital plays a somewhat different role.
Well, sounds like a very busy enforcement agenda. You mentioned Section 19A. For some of our listeners who are less familiar with German competition law, could you just provide a little bit of background on what that is?
Yes, sure. Section 19A is, as far as I know, the only competition provision worldwide that is only dealing with digital markets. That makes it so special. Under Section 19A, we can designate companies which are of paramount significance for competition across markets. That is a long expression. It means nothing else maybe than under the UK regime they are of a strategic market status, something like this. We have designated some companies to be subject to Section 19A. Meta and Google are final. Amazon has appealed. Apple is ongoing, and since yesterday also Microsoft is ongoing to be designated. Apart from that, we have opened proceedings against these companies under Section 19A with regard to conduct. That is a bit similar to the DMA at the European level. And we're looking at certain conduct of these companies. To give you an example, we look at the data processing terms of Google. That is an excellent example because Google, we object, for example, that the user cannot limit the gathering of data to a single service, or we wonder why you have that limitless amount of data that is collected by Google, and we think that the users should be able to limit this. The concern is not so much the user in this sense. The concern is that competitors cannot match with Google if they don't have the same amount, variety, and at the same velocity the data like Google. That is our concern. This is why we look at this. There are other proceedings going on in this respect. A question of if Amazon has a price control regime for the merchants that are on the Amazon marketplace. We look at Google Maps and the implementation of third-party content and the combination with Google Maps. So you see there in digital markets there's really a lot going on. It resembles a bit the DMA, but it's not the same. Under the DMA, you have platform services that are designated. So the DMA is only valid for some services of a company. In the German law, we designate the whole company to be subject to Section 19A. Another difference is, under the DMA, you have an exhaustive list of do's and don'ts of conduct. That again is different under German law. We can look at any conduct and see if it is anti-competitive or not. So there are similarities, but there are also differences, and that remains on top of our agenda. And of course, last but not least, but I must mention it, there's still the old big Facebook case that we have concluded in 2019, which is still with the European Court of Justice, a very important case as well, because this is about breaking dominance by divesting the data that a company holds, by saying that if you collect data from various sources and the user does not agree to assign all that data to one single account, well, that is the choice of the user, and you have to abide to that. That is the idea, to break data-driven dominance a little bit by keeping the data separate and not combining it. Another area, of course, is what remains important for us is the change to the green economy. That's going to be an important point. We have lots of corporations in Germany with regard to the transition to a green or greener economy. We give a lot of guidance with this respect to companies. This is not so much about enforcing cartel law through proceedings. This is very much about giving advice and saying how they could do it and what we do not like in a certain cooperation agreement. We have cases in lots of areas. Animal welfare is one area. Another area is fair wages in the banana sector with regard to foreign countries. In the milk sector, or as I said, all kind of agreements. And I think that is something to do for the future for us.
Yep. So it sounds like you have a lot going on right now, but as you mentioned, the future, to gaze into the future, what do you think are going to be some of the most important trends over the next few years in competition law enforcement?
Yeah, I think the present will be very important for the future as well. I mean, one trend that we must observe as competition agencies, if you look at digital markets, is the development of artificial intelligence. I think from a certain point this is worrisome, what is happening there. I read a German newspaper today that a group around Elon Musk has said today we should immediately stop all further development of artificial intelligence if we do not want to destroy our civilization.
That is brave worse.
That is very far-reaching, of course. But one thing is for clear: we already have lots of competition problems in digital markets. The companies that do most in the area of artificial intelligence are those companies that already have all this data, that are already working in these markets. So I do believe that artificial intelligence will make our life not easier in the future. We do not have cases on that yet, but I'm afraid there will be cases because, as I said, the situation is not going to get better, the competitive situation, just for the reason that you need data to apply artificial intelligence, and who has most data? Those companies that we are working with already or working on today. So I think that will be very interesting for the future. Another thing that we haven't seen so far that much are the very big corporations in the energy sector. But I think that will be an important topic, because the more we switch from fossil energy to renewable energy, the more important gets a happy few that are still producing fossil energy. And we see already in Germany that their market power is increasing. You know, it's a transition of the market, but for a certain period of time, those which are left get more market power. I think that is something that we need to look at, and that will be important in the future. A third question is but that is maybe the most difficult one, is inflation. We struggle with inflation throughout the world, at least in the US, in Europe very much. I think inflation in US is different from the one in Europe. The one here is maybe very much driven by powerful companies. In Germany it was more driven by energy due to the dependence on Russian oil and gas. That is a factor. But policymakers call upon competition agencies to do something against high prices. And that is difficult because we are not price agencies, we are competition agencies. How we solve that, that will be a topic for the future, I'm pretty sure. We struggle with that already. We try to monitor the markets. I mentioned already the sector inquiry on fuel. We are continuing this one. So I think in a first step, we are well advised to know exactly what is going on in the markets. This is what we do. Competition advocacy is important. It is important that those companies which are part of these increasing prices, they know they are watched, that competition agencies are looking at them. But one thing is also clear, it's not the first task of competition agencies to take care for inflation. That remains with the central banks. And I found it a bit funny that Madame Lagarde has just recently said, well, maybe competition agencies should look at the high prices. I'm not very sure that she knows what she has said there.
That's funny, and certainly a lot of important trends to keep an eye on. And I think it's safe to predict that competition enforcement and competition lawyers will be very busy over the next few years. To shift gears a little bit, you've been with the Bundeskartellamt for over 2 decades. You must have seen a lot of lawyers advocate in front of the agency, probably some good, some not so good. What advice would you have for practitioners who want to advocate effectively in front of your agency?
I think in Europe, or especially in Germany, we have a very good relationship between the agency and the lawyers and the companies. In Germany, some speak of a competition family, including everyone, but it's at least a competition community, because in Germany, everyone has a strong feeling that competition matters, that it is important for the economy, and that is the key driver of low prices, innovation, and good quality. That might sound trivial now, but in this world in which we live in, that cannot be underlined enough. And I think it is good that we have this relationship with the practitioners, that they also have this in mind. Having said that, I think we are, compared to the US, I mean, there are 3,000 people, lawyers here in this hotel for the time being. Compared to that, of course, the competition community in Germany is much smaller, which might make it more familiar. But we give a lot of guidance to companies. They don't only come in if we call them, they also can come in to get guidance and to get advice, and we do that a lot. So we have quite a cooperative style of work with the competition community. Just to give you examples, we just recently had a couple of crisis management initiatives. For example, on the cooperation between 3 big gas importers on LNG terminals in Germany had to go very quick. We were there, we gave advice. How do you do that without inflicting competition law? That went very well. We give advice to the German Association of the Automotive Industry in terms of crisis, how to best cooperate in order to get some obstacles out of the way. We also do that in the framework of the European Competition Network, which means it's not only Germany that is handling that is handling it like this. I took care as the chair of the ICN steering group that we did this joint statement also within the ICN as the steering group to underline this cooperative element. I think that is very important for us. Also in mergers, we expect companies and lawyers to come in for a pre-notification case. We don't like to be surprised by cases. So this cooperation feature you find in all areas, I would say. On the other hand, of course, if necessary, we won't shy away from any proceeding and from any tough decision. So it's both, I would say. But I think most lawyers, corporate lawyers are well advised if they care a little bit for cooperation management with us. That helps.
Sounds like it's a better idea to ask for permission rather than ask for forgiveness. One final question. We like to get to know our guests not only as professionals but also as people. Could you tell our listeners some interesting hobbies or accomplishments you may have outside of competition law?
Yeah, that's maybe the most difficult question of all. I work a lot. I mean, there's very little room for hobbies and this kind. What I like walking. I like long distance walking, not climbing, but long distance walking through the Alps, for example, but also in my hometown in Bonn in the Rhineland. I have a dog, which needs some care and with whom I walk as well. And most important for me, I'm an absolute family man, and I spend a lot of time with my wife, with my kids, and that takes a lot of time, and this is most fun for me, and this is distracting me most from everything there is.
Well, walking through the Alps sounds lovely. I love walking through nature. I'm trying to convince my kids to get out on hikes more, but it's an uphill struggle with them. Well, thank you so much for being on the program, President Mundt. We really appreciate having you on.
Thank you for having me.
In the next half of this episode, we'll hear from Cani Fernández, the president of the Spanish National Markets and Competition Commission, or CNMC, about what's happening in Spain. During this interview, you'll hear me mention that President Fernández was the featured guest in a previous episode of Our Curious Amalgam. That episode was part of a series of interviews with international competition agency chiefs who also happen to be women with inspiring career paths. If you're curious to hear more about the competition regime in Spain, the CNMC's work, and President Fernández herself, look for the link to episode 177 on the webpage for this episode. We're happy to have with us today President Cani Fernández of the Spanish National Markets and Competition Commission. Welcome to Our Curious Amalgam.
My pleasure. Hello.
Hello. One thing we'd like to know is, what is the Competition Commission's top priority in the coming year?
Well, last week I had my annual hearing before Congress. I have to go there once every single year. And this year, in fact, it was an important one because it is the middle of my mandate. So it's now 3 years since I took office and 3 more to come. And I had the chance to discuss with the members of the Parliament all the CNMC's challenges and priorities for the coming years. In fact, the economic framework has dramatically changed since I took office. Nobody expected a pandemic and then a war in Europe or skyrocketed energy prices. This has caused serious economic disruption that Europe is facing. And in such context, it is crystal clear that the CNMC, we are going to play a crucial role for the national economy. Therefore, back to your question, I cannot focus on one single priority, but a set of them to make markets work for people and companies in these so disruptive times. Since the beginning of my mandate, fighting against bid rigging, and in particular procurement collusion, has been at the top of our priorities. Now it is more crucial than ever, particularly in the context of the allocation of the European Union Next Generation funds. This priority involves advocacy and enforcement efforts at the time. And in this regard, we have just been awarded a new tool that will draw huge attention in the next months. Is Article 150 of the Spanish Public Procurement Act. And by way of this article, contracting bodies must inform the CNMC of or regional competition authorities. We do have as well competition authorities at regional level in Spain, of any signs of collusion they may detect on ongoing bids. The public bid procedure will then be suspended for a few days while the CNMC analyzes these suspicious signs. And the enforcement of this article will entail close cooperation between public procurement bodies and the Spanish competition authorities, both the CNMC and the regional competition authorities. It will also involve the closer and faster examination of potentially harmful anti-competitive behavior in public tenders before the harm is materialized, and that is the important element. Suspension provides for a clear pre-enforcement. And this will provide us with a huge deterrence effect in future public bids once companies learn that this Article 150 is in place and it works. In addition, the work of the Competition Advocacy Directorate and the Competition Directorate together, training public officials to design and draft competitive public tenders and to detect signs of collusion, is also essential for the success of this tool. Second priority that goes in the same mood is the strengthening of our economic intelligence unit, which will allow us to improve our ex officio detection. We have been one of the pioneering authorities in Europe in creating this type of unit. Many authorities have approached us in order to know about the dynamics, and we've been happy to help them learn from it. It applies statistics, big data, artificial intelligence to uncover illicit conducts, particularly cartels. By doing so, the Economic Intelligence Unit allows us to identify sectors which we should target more narrowly, to improve our inspections, and also to provide case handlers with useful insights as regards the impact of anti-competitive conducts. We are currently closing the numbers to our annual report 2022, but the Economic Intelligence Unit analyzed 232 cases last year. This activity results also boosted by the what we call SICA. SICA, S-I-C-A, is a whistleblowing channel that allows encrypted communication between the CNMC and any citizen that would be willing to provide information about anti-competitive behaviors in a completely anonymous matters. If willing to do so, not even the CNMC would be able to track down the identity of the informant. So informants are protected and should fear no retaliation measures. And this is significantly increasing citizen collaboration in the detection of anti-competitive practice.
Yeah, I think your agency is going to get busier and busier is what it sounds like. We also wanted to ask you whether you saw any trends in the near term with respect specifically to competition law enforcement. Are there any types of behaviors that you're seeing more of?
Now we have to talk about digital markets. That's going to make a huge difference in Europe and in Spain as a consequence. Once the DMA is really enforced, the Digital Markets Act, as you know, is now in the process of being designating. The European Commission is designating the gatekeepers, but this DMA, as the final text was approved, also allows for monitoring and enforcement by national competition authorities if authorized or entitled by our parliaments, and we are in the process of asking our parliament to entitle us. So this is going to be a multiplying factor which will boost our enforcement in digital markets. Also because, as you know, DMA is a complementary tool to competition. It's not one or the other, it's both together. And this is going to require lots of coordination in order to avoid situations of nebis in idem between not only national competition authorities and the Commission, but also regarding behaviors of companies in the digital area that could be captured both by DMA and competition law. Also, we've been focusing very strongly in abuse of dominant position cases because markets are becoming more and more concentrated, and we see an increase of market power, and in particular in the area of pharmaceutical products. So we expect to continue in that vein for the new trends in the next 3 years to come in mandate. Yeah, we, for example, issued 5 unilateral conduct decisions in 2022. As you know, these are kind of behaviors that require lots of effort because they are complex, and the analysis that you have to provide there in order to prove the existence of the abuse is not easy. But all in all, I think we will be enforcing, of course, unilateral conducts and collusive as well. But I think that digital is going to be probably the most important element for our enforcement.
Okay, and for the parties that are involved in these cases in which you're enforcing the laws, what advice do you have for their lawyers?
Well, I would like to send a message that CNMC is more an ally to practitioners than the enemy, and that because at the end of the day, and I say this coming from my past in the other side, if you believe in competition, I mean, that's what you are going to be doing. I mean, trying to have competition as it should be. And no matter which side you are taking, competition is what we all seek. So from my point of view, one of the main recommendations for practitioners would be to encourage their clients to apply for leniency, for example, in cartel cases. We haven't seen this decreased trend in leniency applications in Spain, maybe because our ex officio detection is increasing. We get lots of leniency, or second in, better said, requests, and it is an efficient tool, and I believe that now that we are more credible in ex officio detection, probably that will encourage as well leniency applications to come. So I would send a message to practitioners trying to do this balancing of benefits and risks with their clients, now that we are also going to have an increase of the amount of the fines for directors in companies. It's going to be increased to 400,000 euros. It is now in discussion in the Parliament, not only for companies but also for executives or directors that are involved in the practice, because they are the ones that have the possibility of not giving the information, not going to the meeting. So we believe that's sufficiently deterrent. And also because we are going to apply ourselves the ban to public procurement. So we will be imposing ourselves the prohibition to companies that have infringed competition of contracting with the public bodies. And this is also a very deterrent mechanism. So all in all, I would ask my former colleagues to do the analysis of benefits and risks and try to help their clients in minimizing these risks by using both more lenient applications and more compliance programs that could be helping them in avoiding this public administration ban or public procurement ban.
Okay, well, I hope that they're listening. And just to sort of wrap up the interview, as you might remember from the full episode that we did, that we featured you on last year, we'd like to learn a little bit about the person, that we're interviewing. And so anyone who wants to hear more can listen to your episode. But we wanted to find out, if you're doing anything interesting now outside of your professional life. What do you do to unwind from all of the heavy work that you're doing?
Well, I'm doing two things that are making me really happy. One is helping my husband with a foundation that identifies very brilliant students that are not having the possibility of going to university and then helping them. We've created that foundation several years ago among several friends, and we have already over 80 people that are having their career secure because of that, and we are extremely happy. They have to help others. That's the, let's say, condition in order to be granted with our help. And the second thing that makes me really happy is that now I have a 7 months old baby. Not mine. It's my grandchild.
Oh, congratulations!
Which is even it's better than when you have your own child, because when you are tired to play with them, you can get them back. But yeah, I'm really enjoying this new role. Yes. Absolutely.
Oh well, I hope you continue to enjoy it.
Thank you so much.
Thank you. That's all for today's episode. Thank you to my co-host, Sergei Zaslavsky, and to our distinguished guests, Andreas Mundt and Cani Fernández. We're featuring interviews with many other international enforcers in past and future episodes of Our Curious Amalgam. So if you're curious about what they have to say, listen and subscribe wherever you get your podcasts.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.